So this video is about how estate law and the NFL bylaws may ultimately force the Tom Benson Trust to sell the New Orleans Saints. Hey everybody, I'm Paul Rabelais. I'm an estate planning attorney all around South Louisiana. I've written a book on estate planning for people in Louisiana. Been asked a number of questions over the years about how Tom Benson's passing can affect the ownership of the New Orleans Saints in the future. Let's dig right in. I'm going to take you through 3 or 4 different areas. First is the estate tax. Normally when somebody dies in 2018, the first $11.2 million exempt from federal estate tax, which happens to be about 40%. Everything above $11.2 million is taxed at 40% of the value as of the date of death. Now, I don't know what the value of Mr. Benson's estate is, but it's been reported the Saints are worth $2 billion, the Pelicans worth $1 billion. I know there's other assets out there, but let's just say $3 billion. You multiply that by 40%, you get a $1.2 billion estate tax bill, due 9 months from date of death, due of course in cash to the IRS. It's a big problem for NFL owners. And so we're going to go into, what some of the planning goes into avoiding that. But just to give you a couple of other NFL examples, years ago, Joe Robbie's estate had to sell the Miami Dolphins to pay their roughly $50 million estate tax bill, which is just a pittance compared to the potential estate tax here. Another example, the Kansas City Chiefs, Lamar Hunt bought it in 1960 for $25,000. What a bargain. 1997, he realized there was the potential for a serious estate tax problem. He gave 80% of his team away to his daughter and 3 sons, and he did it because he knew that the value was about to significantly appreciate it. Still cost him $100 million to the IRS just to give that amount to his children, but what it did was it got all that future appreciation of the team. It removed it from his estate, so when he died 10 years later, his children already owned the bulk of the team, and Mr. Hunt had already paid the gift tax on that transfer. So those are some of the issues that owners face. These days, it's really too late for these owners to do any real maneuvering because the values are so significant. But he did take advantage of a couple of rules. One's called the marital deduction. What it means is that when a person dies, they can leave assets for the benefit of their spouse, and their estate gets a deduction for anything that's left for the benefit of their spouse. So while his gross estate might be $3 billion, he left it all into a trust for his wife, and so his estate gets a deduction for all of that. So his net estate for tax purposes is roughly, zero. So what his will did was his will left everything to what I'll call the Tom Benson Trust, the terms of which are private. But then the next provision in his will said, if the Tom Benson Trust is not in existence when I die, then I leave my estate to a trust, the terms of which we do know because they were in his will, which is public. So I got to think the terms of the trust, which we do know the terms of, are very similar to the terms of the trust that we don't know the terms of. So what he did and what he had to do for estate tax deferral or avoidance purposes was say it's all left into a trust, and Gail gets the income from that trust for the rest of her lifetime. Had to do it that way. He named Gail and one other person as the co-trustees of that trust, but he did carve out and say that Gail had the sole right to exercise all voting power over Benson Football LLC and Benson Basketball LLC. Why did he do that? Well, it may have been triggered by a provision of the National Football League Constitution and bylaws, which says that if a member/owner dies, their membership in the NFL may be transferred to an immediate family member without having to go through all the vetting process and getting league approval and commissioner approval and all of that. So by leaving it into a trust and saying Gail has the sole voting power over all the Benson Football LLC operations, that may have been enough so that the transfer doesn't have to be vetted, approved by 3/4 of the league owners. It qualifies under this. You can transfer things to a immediate family member and wife is defined as an immediate family member without having to go through that approval process. Okay, so the potential for a problem as far as ownership comes when Gail ultimately passes away. So what they did, or what Tom did in his will, in his trust that's in his will, he says, I leave it in a trust for Gail to get the income for life, and then when she dies, then the trust is to go half to the Gail and Tom Benson Charitable Foundation and half to Gail's estate. Not sure what she's doing with it. Maybe she's leaving it to their foundation as well. And initially I'm thinking, wow, what a smart estate tax maneuver. You know, their estates will be avoiding estate tax because they took advantage of the marital deduction when the first spouse died, and then they took advantage of the charitable deduction after the surviving spouse died. Not unlike Bill Gates, Warren Buffett, and other very wealthy people. They're all leaving their estates or the bulk of their estates to charity to avoid the estate tax that would be due. So I'm thinking that's great. And then I took a look at the NFL Constitution and Bylaws, which says Article 3.2a, no nonprofit organization nor any charitable organization shall be eligible for membership in the National Football League. So there's a couple of exceptions of teams that were grandfathered in under this who can be a member of the NFL. Green Bay Packers, owned by shareholders. That was done a long time ago. They were grandfathered in. I think the City of Houston has a 5% ownership interest in the Texans. Again, all done before this new rule on who can be an owner of an NFL franchise or a member in the NFL. So rules are real clear, and there aren't any charities that own NFL organizations, but Tom Benson left his estate in large part to their charitable foundation. So what may happen at the end of the day, the charity who can't be an owner is going to have to sell the franchise to, you know, the highest bidder to maximize what the charity gets, because the charity's got to do its charitable work. So it's estate tax rules may have driven Tom Benson to leave his estate ultimately to their charitable foundation, but it's the NFL Constitution and Bylaws which prohibit a charitable organization from being a member in the National Football League. May have to be sold at that point, not so much for estate tax purposes, but because of the NFL's prohibition on a charitable organization being a member in the NFL. So we'll see how it all plays out. Kind of interesting. Know there's lots of passionate Saints fans out there wondering what's going to happen, in years ahead with their beloved Saints. So as I get information, I plan to pass it along. Got a lot of respect for everything Mr. Benson did with his businesses, with his charities, with his Saints. Hope he rests in peace. Hope this helps give you some guidance. Y'all have a great day.